Welcome, and thank you for joining us for our next presentation in our Animal Law CLE series. My name is Pamela Hart, and I am the Executive Director and Assistant Dean at the Center for Animal Law Studies here at Lewis and Clark Law School. Joining me today are Clinical Professor Erica Lyman and Senior Staff Attorney Nick Fromherz of our Global Law Alliance for Animals and the Environment. The Global Law Alliance works to protect animals and the environment through the development, implementation, and enforcement of international law. Erica and Nick will be sharing their expertise in this presentation on learning from Lacey, structural legal collaboration under the proposed UNTAC Wildlife Crime Protocol. And with that, welcome Erica and Nick.
Thank you so much, Pam, for hosting us. We're excited to be doing this with you and to be talking about such an exciting issue. What we want to introduce and talk about today are some new developments in international wildlife law, and to talk about how the next potential international agreement on wildlife could really make some significant headway in tackling the enormous scale of global wildlife trafficking, and then particularly how the proposal for this new agreement draws on a core feature of US wildlife law, the Lacey Act. Amazingly, even over a century old, the Lacey Act stands as a global model for addressing the modern modus operandi of illegal wildlife trade. We've come to this work as the Global Law Alliance with years of experience working with governments to build stronger legal frameworks to combat wildlife trafficking around the world. The Global Law Alliance has worked with governments and partners across Latin America and Africa to strengthen wildlife legislation, ensure that wildlife offenses trigger important ancillary legislation, such as money laundering, conspiracy, and criminal association offenses, and train enforcement officers, prosecutors, and judges on best practices for combating wildlife crime. What we hear often in this work is that there are often structural challenges in the application of the law that sometimes inhibit ability to fully prosecute and combat wildlife trafficking. So we're hopeful that these proposals and ongoing conversations around the Lacey Act and this new draft protocol help to bridge that gap. So with that, let me introduce the main topics for today's conversation. Our approach today is to raise some awareness around the idea that countries would be taking an enormously valuable step toward ending wildlife crime if they supported a new draft protocol to the UN Convention Against Transnational Organized Crime, or UNTAC, which has been proposed by the NGO coalition End Wildlife Crime and supported by many other NGOs, including ourselves. In order to get there, though, we're going to provide some context. So first, we're going to discuss the scale and character of illegal wildlife trade, with an emphasis on its global nature and the complexity of the movement of wildlife around the world. We'd like to then do a very brief primer on the Lacey Act and how it responds to illegal wildlife trade, particularly by looking at its incorporation of foreign law and then some of its mens rea standards, which are potentially very helpful in this context. And then third, we're going to talk about the draft wildlife crime protocol to UNTAC and explore how it builds into its framework a request that countries adopt Lacey-like legislation. So with that, I'm going to turn it over to my colleague, Nick Fromherz, to talk about illegal wildlife trade.
Thanks so much, Erica. And we'll get right started here with the first topic, which is taking a look at the factual scenario, if you will. What's happening in the world of illegal wildlife trade? What is its character? What is its scale? Are there some salient features that we should keep in mind when thinking about legal responses to the phenomenon? So we're going to do this briefly, but hopefully we can tease out a few important points. So any analysis of the best legal response to a problem, of course, requires first a decent understanding of the character of the problem at hand. Now, in the case of illegal wildlife trade, it is a bit risky to generalize. That being said, there are a few overarching features that stand out and that mark and characterize illegal wildlife trade around the world. So first, it's a moneymaker. The graph on your screen shows that environmental crimes, those are set out in the sort of olive shaded bubbles, they rival many, quote, traditional forms of transnational organized crime in terms of annual revenues. If we take a broad view of wildlife trafficking, and we include illegal logging and associated trade, we include illegal fishing and associated trade, and then trafficking of all other flora and fauna, we end up with an estimated total of 153 billion US dollars in revenue per year. So that's a lot of money, and you can see how it compares to some of these well-known, very big money global rackets like the drug trade. Next, illegal wildlife trafficking is a very complex industry. At the international scale, these are process crimes involving various stages from collection to domestic transport and processing to export and import to wholesale and retail sale, and some other associated stages along the way. And all of this is further associated with ancillary related offenses like money laundering, fraud, bribery, and other forms of corruption. Next, it's often transnational. Now, to be sure, there is plenty of wholly domestic wildlife trafficking within many countries. Species taken from country X, transported domestically within country X, sold, for instance, as a pet within country X. So that happens. But in many instances, illegal wildlife trafficking involves trafficking specimens across international borders. Next, and this is a very interesting point, I think, the illegal wildlife trade sits alongside and coexists with the legal wildlife trade. Unlike some illegal industries, most notably, for instance, the cocaine industry, many wildlife specimens are often the subject of legal trade and legal markets. So this permits things like specimen laundering, passing off illegal specimens as legal specimens, and generally makes investigators' jobs that much more difficult because they have to distinguish between the illegal trade in specimen X and, in many, many cases, a legal trade in that same specimen. Next, we have to recognize that the illegal wildlife trade, like all other transnational rackets, responds to market laws. It responds to supply and demand. So it's driven by consumer demand. People all over the world pay money for wildlife products, and both the illegal and legal trade sectors respond to meet that demand. And finally, as a result of this supply and demand dynamic, trade generally flows from the global south to the global north. That's a generalization, to be sure, but let's take a look now at the next slide to see how this maps out. So here we have a map that shows us the major trafficking flows of flora and fauna around the world in gross terms. Those are the black arrows. And we can see that a lot of that is flowing from biodiverse countries in the global south to wealthier consumer markets in the global north, by and large. Now, this map also shows us flows of, quote, traditional legal trafficking, drugs and human beings specifically. In both cases, right, we see that same, in general terms, flow from north to south. The takeaway on this point is that consumer countries, which are largely in the global north, need to do more to crack down on illegal wildlife trafficking and to support source countries and their conservation laws in that effort, right? This is a crime that is taking place across both source and demand or consumer countries. But there is something else in this map that I want to highlight. It shines a spotlight on the role of transit countries. In this map, major transit countries or transit regions are set out in yellow. And these countries are, as the name suggests, neither source countries nor end consumer destinations. They're important way stations or pass-through points along the trafficking route. And they play an often overlooked role in the trade. To cite just one example, which we'll revisit towards the end of this presentation, the Natural Resources Defense Council recently released a report documenting the United States' role as a transit country for shark fins from Latin American nations to Asian nations. And so the fins, right, are passing through the United States. In some cases, those are illegally sourced fins. Now, in the absence of a tool like the Lacey Act, as we'll see, transit countries often have limited opportunities for enforcement and prosecution. After all, the specimen wasn't poached or taken from the transit country. It's not being imported and sold in the transit country. So in many cases, transit countries may feel, and they may accurately feel, like they don't have the legal tools or enough legal tools to craft a strong response to the trade that passes through their borders. And now we're going to move on to the next topic, which is taking a look at the Lacey Act and how it responds to the illegal wildlife trade. So let's now move kind of from the global factual landscape to what's happening in the United States with the Lacey Act as a piece of legislation that responds to this situation. And I'm going to pass it back to my colleague at this point.
Thanks, Nick. So this slide here provides a quick overview of the provisions most relevant in the Lacey Act to the global movement of illegal animal products in particular. And as you can see here, sort of in sum, what the Lacey Act does is it makes it illegal to import, export, transport, sell, receive, acquire, or purchase any animal. In this case, we're emphasizing animals, including fish and including parts and derivatives of those animals, taken, possessed, transported, or sold in violation of any foreign law. There are also predicate violations that pertain to tribal law and state law. Right now, our emphasis is on foreign law. A couple of points here are noteworthy, just to sort of add some emphasis to the broader scope of the Lacey Act. One, as you can see on this slide here, the scope of the law is slightly different for plants. It's a rather marginal change in that some of the foreign laws that might function as predicate violations for animal products, for the Lacey Act's application to animal products, would not necessarily serve that same function for plants. So there's a slightly narrower universe in terms of potential predicate offenses, and we'll talk more about predicate offenses and the role they play in the next slide. Another sort of element of the Lacey Act that is quite important to U.S. efforts to combat wildlife trafficking are its provisions on marking, false labeling, and certain required declarations that must be made. If these are not undertaken properly, or in the case of false labeling, if wildlife products are misidentified, that results in an offense or a violation of the Lacey Act. What's important here, as you can see, is like these offenses don't depend on a predicate violation. They are in and of themselves helpful to address the fraud that often is attendant to illegal wildlife trade. So important statutory provisions. Our focus here, though, is on sort of this first aspect of the Lacey Act that we've highlighted, where it makes it illegal to undertake certain activities in the U.S. With respect to any animal, which is also important, taken, possessed, or transported or sold in violation of any foreign law. So before moving quickly to the next slide, I just want to again emphasize that we don't dig into this very much in this presentation, but it is worth noting that the scope of the Lacey Act is as applied to any animal. And so, talking specifically about animals, these aren't animals that are, or species that are protected by other US law. So in that way, its scope is very broad, and that's worth just us recalling as we talk more about the draft protocol in future slides of this presentation. But now let's get to what is, one of the more complicated and in many cases, the part of the Lacey Act, the operative part of the Lacey Act that's hard for folks to wrap their head around, particularly when we're introducing this concept in other jurisdictions. So what makes the Lacey Act particularly unique? It's that it incorporates foreign law as an element of US law. And you might say, and we hear this all the time when we're talking to folks about the Lacey Act and what it can do, wait a second, the Lacey Act, that enables the US or puts the US in a position, for example, of enforcing foreign law. And that's not appropriate, right? Or, this sounds to us like extraterritorial application of US law. And if we were to incorporate something similar, that would be a violation of our constitutional principles or other legal principles that scope and apply to the legislation that we're able to adopt. It's very important that we understand that these are both misperceptions of how the law works. They are understandable misperceptions, but it's important that they are misperceptions. So it's not that the Lacey Act says if a person violates another country's wildlife law, that person automatically violates US law, right? That's not what it's saying. Instead, the Lacey Act says, and in effect makes the violation of foreign law an element to prove in a Lacey Act case. So one way of thinking about this is thinking of the Lacey Act as involving a two-part analysis. It's really helpful to break it down this way. Step one is an analysis of the underlying offense committed by the defendant or some other person in taking, possessing, transporting, or selling wildlife in violation of certain laws, including foreign law, as we're talking about here. Step two, then, is an analysis of the activity that constitutes the import, export, transport, sale, receipt, acquisition, or purchase of the wildlife in question. That is the activity that takes place subject to US jurisdiction. So what this means is that those who enforce the Lacey Act are not applying foreign law. As one court put it, rather, they are looking to the foreign law to determine if the Act's provisions are triggered. If so, then it will apply the Act, i.e. the Lacey Act, not the foreign law. So that distinction is really important to make. So the Lacey Act is not prosecuting or extending a foreign law jurisdiction into the US or vice versa. The Lacey Act is looking at the violation of foreign law as an element of the offense occurring in the US. Now, importantly, the ultimate prosecution of the underlying predicate offense remains with the originating country, right? And this is in support of this idea of the US not enforcing foreign law, right? So there's full prosecutorial discretion in the originating country or the foreign law jurisdiction that is serving as host to the predicate offense. And courts have confirmed, in fact, that such prosecution is not necessary for a conviction under the Lacey Act. Also significant is that it's also not relevant that the underlying violation of foreign law is punishable to a lesser degree than the Lacey Act violation. So what that means is that the underlying predicate offense, maybe it's an administrative fine offense, maybe it's a civil offense. Those violations, even though not criminal in the foreign law jurisdiction, serve as predicate offenses for a potential criminal offense in the US, right? So we have this sort of scaling up of criminality that's relevant here. And my colleague is going to pick up further on these threads in a later slide. Briefly, on the issue of prosecution of the underlying offense, as I've noted, the courts have made clear that actual prosecution in the relevant foreign jurisdiction is unnecessary. A prominent case on this issue is United States versus Lee, where several defendants were convicted for violations of the Lacey Act after importing salmon in violation of a Taiwanese regulation. So on appeal in this case, the defendants argued that because only the captain of the boat could have been charged in Taiwan with under the Taiwanese regulation, the defendants in the US court system could not be charged with Lacey Act violations. The court stated that the Lacey Act's criminal penalty provision does not require that the fishermen violated the regulation. Instead, it only matters that they, with the requisite mens rea, took the salmon that had been the subject of the violation of the regulation, right? So this is an important, again, distinction and makes clear that the US is not acting to enforce foreign law. Rather, it is very clearly distinguishing between the actions that may be taken in foreign jurisdictions from the actions that result in violations of US law. In that same case, the defendants argued that since the predicate violation would have resulted only in civil fines, a felony conviction under the Lacey Act was improper. The court also rejected this argument, noting that Congress explicitly took this into consideration when adopting higher criminal culpability requirements as a form of mitigation for just this concern. And so now I'm going to pass back to my colleague, Nick, to talk more about mens rea requirements under the Lacey Act.
Okay, great. Thank you so much, Erica. And here I want to talk about mens rea and also penalties, because the two kind of go hand in hand, as we'll see. As one variable changes, so does the other. So what about mens rea and penalties? Well, let's start with the mens rea question. Does a Lacey prosecution, a criminal prosecution, involving a predicate foreign law violation require that the defendant knew about the underlying violation of foreign law, right? Knowledge, sort of in the model penal code sense of the word? Well, it depends. So in the case of a felony prosecution, a knowing violation is required. And just to be clear, that's knowledge vis-a-vis the foreign law violation, right? The fact that there's a taint of illegality, if you will, derived from a foreign law violation. For a felony, the defendant has to have known about that. And in terms of penalties, and here there's a distinction that we should note between the Lacey Act and the Endangered Species Act, as an example. A felony prosecution for a Lacey violation in this context can yield imprisonment up to 5 years and or a fine up to $20,000. The Endangered Species Act only authorizes a imprisonment penalty up to 1 year. So that's a pretty big difference, and part of the reason why you tend to see a lot of Lacey Act prosecutions and not always as many criminal ESA prosecutions. There are other factors, that's one of them. Okay, well, that's for a felony prosecution. We've got to have a knowing violation and potentially up to 5 years in prison and also up to $20,000 fine. Well, is there a misdemeanor violation? Well, yeah, there is. So for a misdemeanor prosecution, which can yield imprisonment up to 1 year and or a fine up to $10,000, the standard is not knowledge, but due care, i.e. The government has to prove that a person exercising due care, right, the reasonable person in that position, should have known about the foreign illegality. Now, the neat thing about this due care standard, apart from its sheer existence, is that it operates as something of a sliding scale in practice. So if the defendant is, for example, large timber importing company that does, millions of dollars of business a year and is constantly importing timber, more is going to be expected from that company vis-a-vis the due care standard than, an individual person who, for whatever reason, in a one-off kind of way, found themselves in a Lacey Act situation. Okay, so that's for a misdemeanor criminal prosecution. There are also civil penalties authorized under the Lacey Act. The Lacey Act also authorizes civil forfeiture actions. Now, these are different in kind than either the criminal prosecution mechanisms or the civil penalty prosecution mechanisms. Those cases, right, are in personam. They're against named defendants. Here, we're talking in rem actions, so against objects. Under the Lacey Act, they come in two main varieties with different rules. So the first variety is forfeiture of the illegally sourced specimens. So the wildlife itself that has, for instance, been imported into the United States following a predicate foreign law violation. In that situation, there is no need to have a prior criminal conviction in the United States associated with the same incident. The government can just go straight to civil forfeiture. And in those cases, the government actually does not have to prove mens rea of any kind. It simply has to prove that the object is forfeitable. So it doesn't have to prove the underlying violation of foreign law and then that it was brought in the case of an import, but not, that somebody associated with this specimen knew or should have known that there was a predicate foreign law violation, etc. Now, there is a protection for so-called innocent owners. If somebody claims ownership of those items, they can come in and try to block the forfeiture by using the innocent owner defense, which is actually contained in the Civil Asset Forfeiture Recovery Act. But in that case, the burden is on the putative owner to prove that they didn't know, right, or should not have known about the underlying illegality. So that's one brand of forfeiture. The other brand of forfeiture that's authorized under Lacey is more powerful. It is a forfeiture action to forfeit to the government vessels, vehicles, aircraft, and other equipment used to aid in the importing, exporting, transporting, selling, receiving, acquiring, or purchasing of illegally sourced wildlife. But because the stakes are higher, right? These are goods that now are generally going to be, high dollar value items in many cases. This forfeiture option requires that the government first get a felony conviction under the Lacey Act, and also prove that the owner knew or should have known that the vehicle or equipment would be used in the commission of a crime. So that's our quick look at mens rea and penalties under the Lacey Act. Now let's look at 3 cases to give ourselves, some sort of factual examples of how Lacey prosecutions can work out. And in each of these cases, we're going to try to tease out a couple of takeaways. So first we have the McNabb case. Now in this case, defendants had used a small cargo vessel, sort of a cargo slash pleasure yacht, in fact, to go down to Honduras and then to come back importing lobster tails that they had harvested in Honduras. And these lobster tails, at the end of the day, were undersized per a Honduran fishing resolution. So, they were juveniles, right? That were not supposed to be extracted. And they were illegally exported from Honduras, specifically in violation of a local inspection and processing regulation. So the idea there being, right, Honduras, if any lobster is going to go out, that first needs to be inspected and processed, in fact, in Honduras, right? Separating the tails from the rest of the body and so forth. Well, this case went up to the 11th Circuit, and the 11th Circuit upheld the conviction. In this case, a criminal conviction, rejecting a few different arguments. One argument that the court rejected was the idea that, hey, regulations and resolutions, that sounds kind of like small potatoes, in Honduras, doesn't even rise to the level of a statute. That can't qualify as a predicate foreign law for purposes of the Lacey Act. This harkens back to a point Erica was making. And the court said, well, no, that's not right. Congress said foreign law. It used this generic term, this expansive term, to recognize, or in recognition of the fact that a lot of times countries will have laws in the forms of regulations or resolutions or declarations or decrees in ways that don't necessarily match US counterparts. And Congress wanted to be sure that everything that was legally binding, no matter its name or form, or as Erica mentioned in the Lee case, no matter its associated penalties, right? Civil versus criminal penalties, that was all covered and valid as a predicate foreign law violation for purposes of Lacey. The 11th Circuit also did something interesting regarding the determination of foreign law. So the defendants in this case said, hey, we have government witnesses from Honduras and also a local legal expert from Honduras who are willing to testify and did in fact offer into evidence suggesting that some of the laws had since, in Honduras, some of those laws had since been repealed or modified, or in one case declared unconstitutional by a Honduran court. Well, the 11th Circuit said, well, that doesn't matter. It doesn't matter if they, became repealed or void after the fact, right? The district court in this case needs to look at whether the law was valid at the time of the incident. And that's a job for the district court to determine independently. So the district court isn't even bound rather by what Honduras might say or a Honduran official might say. That is persuasive authority, but at the end of the day, the district court has to decide, okay, was this foreign law valid at the time of the incident? In this case, it was, even though there had been some backtracking by the Honduran government after the fact. Our next case here, United States versus 594,000 some odd pounds of salmon. This is an example of a civil forfeiture action targeting, right, the specimens in question that were imported. And incidentally, this is actually the companion case to the United States versus Lee case that Erica was discussing earlier. So in this case, to refresh our memories, salmon had been exported from Taiwan without a required export permit. And in addition to the criminal case, the U.S. started an in rem forfeiture action to take away what in this case was a whole lot of salmon, right? Actually, a lot of money's worth of salmon. And the defendant company came in to try to block the forfeiture action and recover the salmon. Well, the Ninth Circuit in this case said, no, the district court got it right. We're going to uphold the forfeiture, rejecting a few arguments along the way. So the defendant company in this case said, hey, the Lacey Act, you know what? It's unconstitutionally vague. It's unconstitutionally vague because it just says in violation of foreign law. And like, that could be so much, right? What does that mean? Again, does it cover resolutions versus, regulations versus statutes? Of what character does the law have to be? Purely conservation law, or could it be tax statutes, for instance, associated with wildlife? We don't know. That's unconstitutionally vague. It doesn't give the world, and in this case, defendants in particular, enough notice, right? Well, the Ninth Circuit rejected that argument. The Ninth Circuit said, no, there's enough notice given, particularly in the case of a civil forfeiture action, as opposed to a criminal case where the stakes are a little bit lower, so less kind of notice is required. Definitely not vague for those purposes. And more broadly, courts have held that it's not vague for any purposes, criminal or otherwise. The defendants also said, well, wait a second, the Lacey Act applies foreign law in violation of due process. The basic argument here, and Erica also kind of teed this up, is, well, wait a second, United States citizens are supposed to be subject to United States laws. The Lacey Act is making the United States subject to foreign laws. And then the United States Attorney's Office is enforcing foreign laws against defendants in U.S. court. Well, the Ninth Circuit said, no, that's not what's going on. The violation of foreign law is one element of a Lacey violation. There also has to be certain prohibited conduct that occurs subject to U.S. jurisdiction. And as Erica mentioned, the foreign country is free to continue with its own processes of enforcement and prosecution. So no, this isn't Congress just kind of abdicating and saying, oh, the law is whatever, another country says it is. No, that's not what's going on. The last case here, United States versus Mitchell, is an interesting case, mainly for its facts, but I want to pull out one kind of big picture takeaway that's applicable across the board. So Mitchell, in this case, actually worked for the Department of Interior as a wildlife conservation specialist. And he worked, in addition to Washington, D.C., he worked in Pakistan and China and various other countries on conservation projects. And he seems to have taken a little bit advantage of his access to wildlife. And he was found bringing back hides and horns from wild sheep and gazelle that were taken from Pakistan. Well, he was charged with a Lacey Act violation and a whole lot of other violations when he was caught entering the United States with these parts in his luggage, knowing, right, so this is a felony prosecution, knowing that the animals have been taken, possessed, or transported in violation of Pakistani law. The district court in this case found that actually, no, the predicate foreign law violation isn't there. Why? Well, the district court said that the defendant acted in compliance with an exception for a personal baggage exception. That according to the district court's read of Pakistani law, it actually wasn't illegal for this defendant to bring these parts out because it wasn't, commercial in scale or any big size and scale. It was just, in his personal baggage. And another law regarding export, the district court found was unconstitutional under Pakistani law. Now, the district court had been relying on some of its own research and some expert testimony from a Pakistani legal expert to come to those conclusions. The circuit court disagreed on both counts and found that the personal baggage exception didn't cover animal trophies as a matter of Pakistani law, right? The circuit court revisiting what does Pakistani law say and mean in this case. and also disagreed with the district court on the finding of unconstitutionality. Here, and this is the kind of key takeaway point, the circuit court relied heavily on the overall weight of submissions from Pakistani officials and law experts, and found that the balance of those submissions actually supported the circuit court's conclusion and undermined the district court's conclusion. So if we remember back to the McNabb case, where we established that, okay, the district court, ultimately has to determine the state of the foreign law, and foreign testimony and input from government officials can be persuasive, but it's not controlling. Well, here we go back to but it is really persuasive, right? So this is important because, and we'll touch on this when we get to the UNTAC protocol idea, Lacey really can foster foreign collaboration regarding these kinds of prosecutions, right? So that case also shows us that. And now the next slide is going to be much quicker. We're going to take a look at Lacey-like legislation in other countries. So to be sure, the US is not the only country with a Lacey-like law. Laws with Lacey-like elements, right, exist in several different countries, in Canada, in the United States, Australia, and then in a number of countries specifically with respect to marine fish. And you can see some on your screen there: New Zealand, Norway, Papua New Guinea, Solomon Islands. So let's just take briefly a look at one example of a foreign country with Lacey-like legislation in a little more depth. So by way of example, let's look at Australia's approach. Australian law prohibits import of animal or plant specimens when the importing individual knows that the specimen was exported from a country in contravention of that country's law. So right away, we should notice a few things that are different and actually narrower in scope compared to Lacey. First, the law here only prohibits knowing violations, right? So we don't have that due care tier. Also, the predicate foreign law, right? What counts is pretty narrow. It's export, right? It's got to be exported from a country in contravention of that country's laws. So it doesn't cover all of the associated activities like harvest, like processing, transport, etc., that Lacey covers in terms of the scope of the foreign law predicate violation. Next, another narrowing in scope. The Australian approach only authorizes prosecutions when the CITES authority of the foreign country, the source country, has requested investigation. And, the point here is just there aren't unilateral prosecutions under this law. And that may eliminate some prosecution opportunities where the foreign country in question lacks the political will or the wherewithal or the time to request investigation. So the basic point, if we zoom back to sort of the global perspective away from Australia, is actually twofold. First, most countries don't have Lacey-like legislation. And then second, for those that do, they usually aren't as comprehensive or robust as Lacey. And now I'm just going to tee it up here for our last topic, which is taking a look at the draft wildlife crime protocol to UNTAC and seeing how it draws inspiration from Lacey as model legislation.
Thanks, Nick. So a couple of things are really helpful, and I like the way you set out sort of some of these key cases under the Lacey Act in the US, and then sort of, and what those cases tell us, right, is like the Lacey Act is broad and extensive and comprehensive in its approach, particularly as you match it to wildlife supply chains. And although there are these certain analogs in other countries that demonstrate just by virtue of their adoption the potential effectiveness of this sort of structural relationship that we can build into the law, they are oftentimes something less than the Lacey Act. And particularly when we're looking at wildlife crime supply chains, it behooves us to take a broader approach. So let's look at what's being proposed by the Coalition End Wildlife Crime. And I want to start that conversation by just reflecting on this point that you are alluding to, Nick, in your description of Australia's law. And I think what the Australian law is really getting at is that we often hear when we're doing trainings or working directly with ministries on upgrading or enhancing legal frameworks, and even when we're working on particular issues of what we would call illegal imports of certain specimens, whether it's in the context of the Convention of International Trade in Endangered Species or otherwise, we regularly hear this concern that a specimen may be exported from a particular country and that export may have been illegal, and or the sourcing of that specimen, et cetera, may have been illegal. But once it is brought into our country, there's very little we can do, right? So it's like this post-import loophole that exists. It's not always true that that loophole is as broad as it's sometimes commonly construed. For example, customs law and circulation of illegally imported specimens, for example, may be relevant for closing that gap. But the fact that the barrier in thinking through potential wildlife crime prosecutions rests on this idea that after import, our opportunity for prosecution is limited, is a huge challenge for really broadly and at a global scale tackling wildlife trafficking. So what this protocol does, and the idea behind at least parts of this protocol, the parts that we're going to talk about, is to start to close that loophole. And so, we in our work are often sharing and flagging the value of the Lacey Act and encouraging governments to consider the utility of building the structural collaboration into their laws. We would advocate for a broader approach than the, sort of more narrowly tailored examples we might see in other countries. And what's clear is that others too, like End Wildlife Crime Coalition, and the US itself, are proactive proponents of building Lacey-like laws into wildlife legislation around the world. So what we see is this global initiative to end wildlife crime has released the contents of a draft protocol on wildlife trafficking that would, if adopted, enter into force as the fourth protocol to the United Nations Convention Against Transnational Organized Crime, or what we've been referring to as UNTOC. The protocol would do, among several other things, the protocol would require parties to adopt Lacey-like legislation. It's really important that the idea here is to adopt a protocol to UNTOC as the world's foremost treaty on transnational crime. UNTOC, it makes sense that we build out sort of legal commitments and enforcement commitments that are relevant to that treaty and specifically target illegal wildlife trafficking. Other protocols to UNTAC include a protocol to prevent and suppress and punish trafficking in persons, especially women and children, a protocol against the smuggling of migrants, and a protocol against the illicit manufacturing and trafficking in firearms. And so if you think back to one of Nick's first slides showing the value of the global illegal wildlife trade, it sits on par with these other issues that are subject to unique protocols under UNTAC. So a protocol here under UNTAC on wildlife trafficking, it draws very clearly on international efforts to raise the profile of international wildlife trade, including that wildlife offenses should be treated as serious crimes, which is a term of art that we've discussed in other trainings and in our past CLEs. So without belaboring that here, let's look a little bit at the language that's being proposed. And I want to be clear, this is an NGO proposal for a protocol at this point. Although I think it's fair to see that there is a lot of interest in this protocol, and it sort of suits the contemporary mood of countries right now. It's not yet, it hasn't transformed into an official draft protocol that's currently being actively negotiated. We certainly hope that happens, though. So here's the language that's being proposed by the End Wildlife Crime Initiative. And you can see here, just by reading this, where it says, each state party shall adopt such legislation and other measures as may be necessary to establish as a criminal offense, when committed intentionally, the trafficking in any specimen, knowing that the specimen was taken, possessed, distributed, transported, purchased, or sold in contravention of, and then A, any international agreement meeting these terms, and B, or B, any applicable domestic or foreign law concerning the following: the protection, conservation, management, trade, or use of wild fauna or flora. So this is a Lacey-like demand of parties, right? Each party shall adopt such legislation. So if this protocol were to enter into force in, let's say, Bolivia would be obliged to draft and adopt legislation that comports with these standards. We believe that this would just be hugely impactful for the global fight against wildlife crime. This sort of command to incorporate Lacey-like legislation into domestic legislation globally shuts down this sort of import loophole. It does so much to enhance cooperation between governments, between enforcement officers that sit in different jurisdictions, and to ensure that there are checks on international wildlife trade, right? That the burden is not simply on the exporting country to control the wildlife specimens leaving its borders, right? And so demand countries, importing countries have full stop a responsibility to prosecute those cases almost nearly in equal measure, right? With equally valuable tools to do so. That all being said, there are a couple of important distinctions here between our Lacey Act conversation we've just had and what this provision is asking parties to do. In a lot of ways, you might consider it a Lacey, the request to adopt Lacey-like or Lacey-light legislation. It does a lot to view the supply chain holistically in terms of tackling different activities. One thing it doesn't do is that the activity in the country of jurisdiction right, is that it's just the trafficking in any specimen. So what becomes important is that that term is really defined broadly. As you'll recall, in the US Lacey Act, there's a list of activities if undertaken in the US, and a predicate offense in foreign law has occurred would rise to the level of an offense under the Lacey Act. Here it's scoped a little bit more narrowly. The second major issue is that the request of what national legislation should look like hinges on knowing violations and intentionality. And so that stands in pretty stark contrast, as you'll recall from Nick's discussion with the Lacey Act, which incorporates, misdemeanor treatment for due care violations. Given the challenge of proving knowledge, particularly knowledge of foreign law violations, it might be something we're thinking about. Are there amendments here that could incorporate due care standards, in order to enhance the heft of this type of legislation and its value to combating wildlife trafficking, particularly as we think of wildlife trafficking happening at a global scale as being a transnational organized criminal activity, where it might be even harder to prove those sort of knowing violations. Those caveats or observations aside, we firmly, as the Global Law Alliance, believe that incorporating this type of provision into an UNTAC protocol is crucial. And I'm going to pass the mic again to my colleague, Nick, so that he can sort of highlight what we see as some of the value and the situations in which it would be helpful to apply it.
Thank you so much, Erica. And this last substantive slide before we say thank you and goodbye is going to hopefully reiterate and kind of pull together a lot of the threads that we've established throughout this presentation. So what are some of the reasons why, or the advantages rather, of Lacey-like legislation? And how do these advantages lead us to this conclusion that, hey, this kind of Lacey-like command in what is, an NGO at this point draft protocol look pretty good, right? What makes us come to that conclusion? Well, first, let's talk about the fact that Lacey-like legislation captures a whole range of wildlife trafficking scenarios that other laws, kind of more traditional, if we can say, purely domestic laws, in the sense that they don't incorporate, right, a foreign law violation element, leave out. Lacey-like legislation will capture many, many more wildlife trafficking scenarios. Why? Because, well, prosecuting countries are not limited to species protected under national conservation legislation or legislation implementing CITES if they have a Lacey-like law. Any species that is subject to a conservation law, broadly defined, anywhere in the world will receive the benefit of Lacey-like legislation. And this is all accomplished, or could be all accomplished, without the need for the prosecuting country, the country of jurisdiction, to have legislation that specifically enumerates the species as protected. So, sort of by incorporating by reference foreign law, and by having these broad terms like Lacey has, any animal, plant, or fish, we don't have to, or countries don't have to, I should say, go through the political fights and the administrative and legislative lifts to say, okay, we need to list specifically for protections, species X, Y, Z, and so on down the list. You just kind of do it in bulk in a comprehensive fashion. So you capture many, many more wildlife trafficking scenarios by having Lacey-like legislation. Second, and this goes to a point that Erica just mentioned, and I think we've established as a theme here, consumer countries can take responsibility for the demand that they host by enacting Lacey-like legislation. Consumers in wealthier countries drive international wildlife trade to a significant degree. Not wholly, right, but to a significant degree. And it's only right that those countries back up, if you will, source countries. And you can think of that in terms of sort of a share of the consumer country's responsibility. The other way to think of it is that source countries often lack the enforcement apparatuses and wherewithal to stop trade within their borders. Many source countries, we don't want to generalize, but many source countries are developing nations with limited policing and enforcement apparatuses. And so you can think of it in terms of differing capacities as well, right? Many of the consumer countries also have more capacity. And so it's only fair, especially in light of their role in driving trade, that they use that capacity to, again, back up source countries and, more importantly, wildlife around the world. Transit countries, we talked about this in the beginning as well. The Lacey Act and Lacey-like legislation allows transit countries to get in on the act, if you will. Illegal wildlife trade doesn't always flow directly from source to consumer country, right? A lot of times it has to go through other countries, either as a result of geography, could be a result of certain kind of business considerations, if you will. There can be collection centers and processing centers that sometimes happen in other countries. And many times, of course, it is just a matter of geography, like the shark trade that we mentioned, where the United States has been found by a recent report put out by NRDC to be a major transit country for shark fins going from Latin America to Asia. And that one is explained seemingly to a large extent by geography. So the Lacey Act equips US authorities to respond to this. And what's interesting to note is, to kind of go back to a weedy point about the Lacey Act, is import under Lacey is defined to include transit situations, regardless of whether or not the transit situation constitutes importation for purposes of the custom laws. So again, another way that the Lacey Act kind of acts as a model by being as wide as possible, right, within its legislative lane. And lastly, and this is another theme that I think we've established, the Lacey Act and Lacey-like legislation promotes cross-border cooperation. This can happen in many ways. I think it happens in two ways more often than not. First, the evidence collection, sort of the facts of the investigation, and then getting the evidence from source country to, from source country to prosecuting a country, right? Establishing the facts that show, a foreign law was violated. There's going to be almost always cross-border collaboration to support that investigative and proof effort. The second way cross-border collaboration can help a lot, and we saw this in a couple of cases we highlighted on the earlier slide, is on the legal front, right? Expert declarations or foreign government declarations regarding what the law is and what it means. And a lot of times, when the prosecution is successful, that information is going to be helpful for the court to determine that, a foreign law was in fact violated. So with that wrap up, hopefully we have accomplished our mission, and we just want to thank you on behalf of the Global Law Alliance, on behalf of Center for Animal Law Studies at Lewis and Clark Law School, for your attention, and we hope you found this interesting.
Thank you, Erica and Nick, for an excellent and thought-provoking presentation. And thank you, all of you out there, for joining us today. Stay tuned for more on-demand animal law CLE webinars from the Center for Animal Law Studies. Thank you again and have a great day.